First, let me introduce myself. I'm Cliff. I'm an attorney and I practice exclusively Social Security and SSI law. This is all that I do. And I've been doing it for, I hate to admit this, but 45 years. My first case goes back to 1969. Anyway, I'm part of a law center that is devoted exclusively to the Social Security system and the supplemental security system. And usually when I come to one of these presentations, folks have a lot of questions that they want to ask, which is good. And one of the first things I do is first get an overview. How many folks are currently on benefits at the present time? Okay. Have any of you gone through the system and have been denied? Are you still in the process of trying to get approved? Or have you given up? Have you had a hearing with a judge? Okay. And you were denied? Okay. Were you represented? Did you have an attorney or other representative advocate for you? You had an attorney. Okay. And how long ago did you have this? Okay. All right. Now, have you refiled at all or have explored the possibility of refiling? Well, you don't have to answer that. I want to make sure you understand.
That's what I'm doing now.
I'm sorry?
That's what I'm doing right now.
Okay. Okay, well, we'll talk about that then. Okay, for those who have gone through the system and have been denied, that does not mean the fat lady has sung. Okay, there may be opportunities to start over and possibly, in certain situations, reopen a prior claim. That is possible. But let me first explain the two programs so you have an understanding of what we're talking about. Under the Social Security Act, there are what they call titles, and that's just a big fancy name for the name of chapters, okay? Title II is for Social Security Disability Insurance, okay? SSDI. And Social Security they love acronyms, and they use a lot of acronyms. SSDI, Social Security Disability Insurance, Title II. And the other title that the Act covers is Title 16. Title 16 is Supplemental Security Income. Well, you're probably wondering, why do I have to be concerned with these titles? Well, that's the way Social Security is organized. If you go into any office, their folks are divided between the two programs, Title II and Title 16. The problem is, with all the cuts in personnel over the last, probably this has been going on for at least the last 8-9 years, they've lost a lot of folks who really knew and were knowledgeable for both Title II and Title 16. Well, unfortunately, that's no longer the case. So folks who are trained under Title II are not necessarily experts on Title 16, and those on Title 16 are not necessarily experts on Title II. And a lot of misinformation is communicated to folks who wouldn't know the difference anyway. So what I'm going to try to do is kind of give you an overview of what the qualifications are for both programs. And I'm not talking about the medical qualifications, because you can't get to the medical qualifications until you satisfy the non-medical qualifications. And sometimes when you don't meet the non-medical qualifications, they just politely say, we'll let you know, and you get a letter 2 weeks or 3 weeks later saying what we call a technical denial. Unfortunately, you do not meet the non-medical requirements, so therefore it is not necessary for us to go any further in determining whether or not you are disabled enough to qualify for either benefits under Title II or Title 16. So we have to know what the non-medical requirements are. Now, unlike Title II, which is pretty well fixed, it's easy to kind of understand what you've got to show, Title 16 is very, very what we call fluid. It can change just like Michigan's weather from daily. depending upon your fact situation. So when you go into Social Security or call Social Security to find out whether you would or would not be eligible, that may be true as of today. You may not be eligible. But tomorrow or next week, you could be. Things change, okay? Your circumstances change. And the Title 16 SSI program is very, very, very technical. More technical than it really has to be, but it is. And you've got to know what is required in order for you to be eligible to even get to the issue of disability. So let's first talk about SSDI, because that's a little bit easier to understand. SSDI, which is Title II, is based on your earnings. In other words, all of your years of work, out of every paycheck, if you notice on your pay stub, there's a little box that says FICA. That's separate from your state tax, separate from your federal tax, separate from your city tax. It's a little box that's marked FICA. And FICA stands for Federal Insurance Contributions Act. All it is a fancy name for a big fund with lots and lots and lots and lots of dollars. Because out of every paycheck, 7.65% of your gross income, matched by your employer for a total of 15.30% of your gross income, goes into this big trust fund. And what does that buy you? Well, it buys you three things, basically. One, if you've paid into the system long enough, you are going to be eligible for a retirement benefit beginning at age 62. And of course, having the option, as you delay it, your benefits go higher, but it pays for retirement benefits. Secondly, it also provides for a benefit should you prematurely die, leaving minor children and a non-working spouse who's caring for your minor children. Okay, those are called survivorship benefits. And oftentimes you'll know about folks who, a husband who passes or a wife who passes who has worked for a number of years, leaving minor children. These children become eligible to receive benefits until they graduate high school or age 19. If they haven't graduated at age 18, they continue to receive benefits till they graduate or turn 19, whichever first occurs. So those are survivorship benefits. It also provides for a widow who hasn't worked over the age of 50, becomes severely disabled, that too. But we're not going to go. We're going to go with most of the run-of-the-mill type cases that we usually see. There are some rare cases that we'll talk about a little bit later, but the thing to remember is that the word insurance should be kept in mind because you've paid for these benefits. The third benefit is called disability. And if you have paid into the system long enough and sufficiently enough, you now are eligible to qualify for a disability benefit if you're unable to work at your previous job or any other type of work, and that this disability is severe and it's going to last a minimum of 1 year or longer, or can be presumed to result in death, one or the other. Now, the thing to remember is this is insurance. This is not welfare. You've paid for these benefits out of every paycheck. One of the things I get a lot of resistance for are folks who think it's a welfare benefit. Well, it's not. It's like car insurance. You pay for it every year hoping you never have to use it, basically. And that's basically what we're talking about, SSDI, Social Security Disability Insurance. It comes out of your paycheck with that FICA contribution, and it's put in this trust fund, and God forbid you become seriously disabled before you reach your retirement age, you can be eligible for benefits both for yourself as well as for your dependent children under the age of 18 and a non-working spouse with a child in his or her care under the age of 60. Again, this is insurance, and this is Title, you remember what I called it? Title II. Good, great. You're better than some of the people I train and teach. Sometimes I get these faces, they look at me, Okay, so that is Title II. Now, Title 16 is something totally different. The confusion comes because it's administered by the Social Security Administration, and the way they decide whether or not someone is disabled enough is the same as Title II. So before you can even get to the issue of disability, you've got to find out what does it take to be eligible for SSI. And there are different things that apply with SSI, okay? Now, supplemental security income. What is it? It is a welfare benefit. It is a welfare benefit. And the two benefits start at different points, and the two benefits have different ancillary medical programs that you become eligible for. Now, SSI can begin immediately. Again, you have to be poor enough to be eligible. That's the key. And it covers poor and disabled adults, poor and disabled children, poor and disabled aged aliens, poor and disabled aged citizens. That's SSI. It is a welfare benefit. Can you be eligible for both benefits? The answer is sometimes you can. If the circumstances are correct, yes, you could be eligible for both. But Title 16 has its own qualifications. Title II has its own qualifications. Going back to Title II a moment, benefits cannot begin until you're disabled for at least 5 months. 5 months. Benefits begin with the 6th month of your disability. And as I mentioned earlier, if you're eligible for benefits and you have minor children living in your care, or it doesn't have to be living in your care, it could be from a previous marriage, or even with no marriage, your children are eligible for benefits. If you are married and you have a non-working spouse, the non-working spouse can be eligible as well, if at least one of the children are under the age of 16. So Title II is very clear. Now, the key here is, have you paid in long enough to be eligible? And there are special rules for folks under the age of 34. But the rule of thumb is, if you've paid in 5 years in the last 10 years, counting back from the year you became disabled, you are going to be covered under Social Security. To better understand this, let's assume I became disabled in the year 2010. I have to go back to the year 2000, and between the year 2000 and 2010, I have to find 5 years in which I've contributed to the FICA trust fund based on my employment. If I'm self-employed, there's self-employment tax, which does the same thing. Goes into this trust fund, provides the same coverages. The only difference is a self-employed individual is responsible for both the 7.65% payable by the employee and the 7.65% that's payable by the employer, 15%. So it's very clear. That's the premium you have to show. All right? Now, SSI, on the other hand, is determinative on the basis of how many assets you have. Now, here are the things SSI does not count, okay? A home, as long as you're living in the home and you're on the title. There can be 20 people on the title, but as long as you're on the title and living in the house, regardless of value, a home is excluded. In addition, one car, regardless of value, is excluded. One car. Third, assets. If it's a single person, you can have assets no greater than $2,000. That includes cash, stocks, bond, whatever assets you have. It could be a collection of something. It could be a boat. It could even be a junk car, a third car. You'll have to show that the value of that car is below 2,000. Remember, you can have one car. If you have more than one car, then they're going to look at the value of the other car to determine whether or not you're eligible. So these are the requirements you must meet before you can even get to the issue of disability. Benefits start immediately. In other words, the month following the month you apply. If I apply today, September 20th, my first check comes October 1st. And the other thing to remember, there are no benefits for your children and no benefits for your spouse. This is strictly a benefit for you as a poor individual. With regard to a child, it's a little bit different. I'm not going to go into that. That's a whole separate presentation. But basically, that's it. So if you call Social Security or go in and apply, and the first thing they're going to ask you, what are your assets? What are your living arrangements? Are you married? The income of your spouse can also affect your eligibility. They look at the income coming into the household. Now, if you're married, they up it to $3,000. $3,000 if you're married, or if you are living with a significant other, even though you're not married. They look at the assets, the combined assets of both parties living in the same household, and if the assets are greater than $3,000, you are not eligible for SSI, no matter how disabled you may be. Okay? Now, remember I said with Title II, there are no immediate benefits. Benefits don't start till the 6th month of disability. However, if you are poor enough, you can get SSI for the first 5 months during that waiting period, and then when your SSDI benefit kicks in, then your SSI benefit will stop and your SSDI benefit will take over. That can happen, again, if you're poor enough. The other important thing to remember with Title 16, there's immediate Medicaid. Full Medicaid cannot be played with by the state. No modifications to the Medicaid coverage that you are entitled to. As long as you're eligible for at least $1 of SSI, you are eligible for Medicaid, full Medicaid. Okay? Any questions so far? Are we good to go? Okay. Now, with Title II, SSDI, the insurance part, there's no immediate medical coverage. You are not covered until you're on benefits 2 full years. And once you're on benefits 2 full years, it's Medicare, not Medicaid, that kicks in. Medicare, regardless of age, starts with the 25th month of the month you started receiving benefits. And there is a premium that you pay for Part B. Part A is free, Medicare. Part B, there is a premium. And they will presume that you want the Part B Medicare, which is the services, not other than hospitalization, the outpatient services and other services that are related to your illness. The Part B Medicare is paid by a premium that is deducted from your monthly check automatically. So if you're receiving SSDI right now, if you're receiving a monthly check, and let's just say you just started receiving it, let's say within the last few months or so, understand that all of a sudden, when your 25th month of benefits begin, you're going to see a reduction. And it's the presumed Medicare premium that's being deducted from your monthly check to cover your Part B Medicare premium. You follow me on that? Okay. Remember now, SSI is Medicaid. Now, if you are eligible for both, sometimes they overlap, the two benefits. And what they try to do is tell you that if they overlap, why pursue an SSI case? You know, if you've waited a very long time, The reason you want to do that, you don't drop your SSI claim because you have Medicaid coverage all that period of time you've been waiting for this favorable decision to come through. So whatever, and then you'll have a window of about 90 days of overlap where you can use your Medicaid, particularly if you need some type of service such as surgery that you will not otherwise be eligible for until 2 years down the road. So you don't want to dismiss your SSI case, even though it may take a little bit longer to calculate both of them. You don't want to dismiss it. You want to continue the claim. It is always wise to get some guidance before you even file your claim. A lot of folks don't do, most folks don't. They just don't. They just go to Social Security and either make an appointment by calling the 800 number and going in and filing the claim, or walking into a Social Security office and taking a number and waiting until you're called and filing the claim that way. If you can get some guidance, and one of the things we do, and there's no charge to you, and there's no obligation, is give you that guidance depending upon your fact situation. Now, no two cases are exactly the same. You've got to understand that. Whatever you do, don't compare your claim to your neighbor's claim or to another member of your church or another member of your support group. Every case does have its own DNA, and we have to probe a little bit to see what is the best course to follow. Believe me, it's not uniform at all, and a lot of mistakes are made, and usually those mistakes start at the very, very beginning. And they're not forgiving. If that mistake is made early on, it's going to haunt that claim throughout the whole process. So the smart thing to do is get some guidance before you even file. Now, you'll see in the newspapers people advertising Social Security. You'll see billboards, we handle Social Security, we do this. Very few say SSI, by the way. If you notice, they don't say SSI. They don't want the SSI because it's so complicated. It can be very complicated, depending upon your living arrangements, depending upon your assets, depending upon whether you're getting child support, are you getting a pension benefit, are you getting unemployment. All of these things affect your eligibility. And it's complex. And unless you do this every day and keep up with the changes that they make as they go along, you're really at a disadvantage. We try to help folks right from the get-go, whether they come back to us if they need us down the road or not. This is part of what we do. This is part of how we give back, because believe me, I make a very nice living handling Social Security disability, and it's my way and our way at the center. We got 7 lawyers, and you will talk to a lawyer. You will not talk to an attorney, to a law clerk or a secretary or a paralegal. You will talk to an attorney who's got years of experience with both Social Security and SSI to give you the guidance you need. And spread that word, because it doesn't cost anything to get this guidance. It's free, okay? And our number to call us is in your pamphlet. We have a pamphlet that we handed out. It's on there, 1-800-832-3471. It's right on the pamphlet. You should write that down. You should keep it handy. And right next to it, free advice on when, how to file, if that's the issue, whether you're getting the correct monthly benefit. Okay, this is another major, major area. Now, how many of you are on SSI? Or is it all SSDI? Are you on SSDI Title II? Yes, no, or do you know? Does your check come? I'll tell you how you can tell. If your check comes on the 1st of the month, it's SSI. If your check comes, depending on the 2nd, 3rd, or 4th Wednesday of the month, depending upon what day of the month you were born, it's SSDI. So are you getting SSDI or are you getting SSI?
I'm getting long-term from my job.
Oh, you're not getting any kind of Social Security?
No, I applied and I was denied. I'm in appeal.
You're in an appeal now. Okay, well then you've gone through the process.
Yeah.
Yeah. And you're getting a long-term disability through your employer,
Yeah.
correct? Okay. Understand that your long-term disability plan requires you to try to qualify for SSDI.
Right, exactly.
And they're going to coordinate the two.
Yeah.
Okay, did they tell you that?
Yeah.
Did you pay for that private insurance, or was your employer providing that free of
I
charge?
had to pay.
See, here's where you're being kind of taken advantage of. You paid a premium all the years that you've worked for that private LTD policy, haven't you? It's come out of every paycheck, right? And it's tax-free because you paid for it. But they didn't tell you that if you do qualify for Social Security disability, they're going to reduce that monthly benefit by the amount Social Security pays you. Did you know that? Well, now you do. Look now you do. And if you know any folks who are buying this type of policy, most policies will let you pay a little bit more and they will waive the offset. And it's worth every penny to do that, because when you're disabled, believe me, you're in a hand-to-mouth situation. I mean, you don't know where your next meal, where your next utility bill, how your next utility bill is going to be paid. A lot of folks, obviously, no one plans for disability. No one. You know, unfortunately, death is a little bit easier to plan for because that's final and it's not like going on and on and on and on. But it's very true, and a lot of folks are really blindsided. There are so many inequalities that I could go on for a half hour about that, but I'd like to really give you the practical advice that you're going to need to go forward. Now, are you waiting for a hearing now? Is that where you're at the present time? Okay. I assume you're represented?
Yeah.
Okay. Is your case in Detroit? Is it pending in the Detroit hearing office or Oak Park? Or oh, it's in Oakland County, so it's either in Oak Park or it may be in Livonia. One or the two offices. That's good, by the way.
Okay.
That's good. The Detroit office has turned very, very conservative, and you have a much better shot either in Oak Park or Livonia. What community do you live in Oakland County?
Southfield.
Southfield? It'll be Oak Park then.
Oh.
It'll be heard in Oak Park. Yeah. Anybody else have a pending case now? Anybody getting SSI? Are you getting SSI? It comes the first of the month. Anybody? Okay, and it comes the first of the month. Are you getting $710 a month?
Yes.
Okay, that's the maximum. A lot of folks, for whatever reason, are not getting the maximum. That's why I always ask, because if you're not getting the maximum, I will tell you how to get that monthly benefit raised. But anybody else getting SSI?
I have a question.
Sure.
You said the maximum of what he's getting is how much?
$710 a month. That's SSI, not SSDI. That's Title 16. Now that changes every year. It goes up. There's a cost of living increase that they usually give each year. A couple years they didn't because there wasn't any increase in the cost of living. But usually there is, and it goes into effect the first of the year. Okay? Anybody else is anybody getting both benefits, SSI and SSDI? Sometimes that happens. When I say the maximum SSI benefit is $710 a month, if you're getting SSDI, which is less than $710 a month, you may be eligible for an additional benefit that you're not getting now. Now, sir, when you were awarded SSI, had you been out of work for a very long time?
Not too long, about 3 years.
Okay, when you applied and told them the date that you became disabled, did they accept that date as your onset date? Do you recall that?
I was denied at first.
You were denied. You had to go through a hearing?
Well, I was in the coma the next year and they had approved me. I didn't even know it was approved.
Okay, what's going on? Okay, I'll tell you what's going on. I'm going to tell you how the medical decision is going to be made, and this will give you a better idea and some practical advice for folks who are already, or who haven't gone through the system yet but are about to do so. The way the medical decision is decided is When you go in and file your claim, you have 3 ways of filing a claim, and this is both SSI and SSDI, Title II and Title 16. You can file by phone and mail, and you call the 800 number of Social Security, and they will give you an appointment for a phone interview, and they will handle everything by phone and mail. Now, that's okay. The other way is by going online and filing online. Do not file online unless you have somebody else do it for you. Why? If you file online, you're telling them you are able to do data entry skills, okay? And that's one of the real problems we can have later on at the hearing level. Not necessarily, not all judges pick up on this, but a lot of them do. And I've run into this already a couple times. You don't want to file online. It's okay to file by phone and mail, and it's okay to file in person, but not online. Now, another thing, for folks that you know that may be going through the system or re-going through the system, if you have any demonstrative evidence of limitations, meaning that if you walk in and I'm the claims representative and I look at you and I talk to you back and forth, do I see any problems you're having with sitting or standing or writing your name or communicating or being able to sit still or having to use the bathroom 20 times during the interview? You want to file in person, because the initial medical decision that's made in your case is made by somebody who never lays eyes on you. They rely on what other people observe. And the first person they look at is that claims representative that you meet at the time you go in and file your claim. Now, there's nothing wrong with filing online if you have either a representative early on during your initial application. They'll do it, and they indicate that they're doing the data entry and all that, and not you. Or if you have a relative who's going to do it for you, make sure you say, my sister, my uncle, my brother, whatever, did this for me. I didn't do it myself. My neighbor, my friend, my child. Don't yourself do the data entry, okay? Very important. Now, if you don't have any demonstrative evidence of limitations, like all of you look pretty good today to me. You look great. You want to file by phone and mail. You don't want to have those observations being an impediment to any decision that will be made at the initial level. The initial level takes about 90 days for them to make the decision. About 90 days, 90 to 120 days. Actually, the longer it goes, the better it usually means that your case is really looking strong and they're looking for a way not to pay it. Bottom line, that's basically what happens the first rung of the process. They only pay about 30% of the cases on the initial application, very small percentage. And these are mostly really catastrophic, major problems. The more, less, I guess, not less severe, but probably conditions that aren't readily observable or whatever, those kind of the cases, they generally are going to deny, and your best shot at winning these cases are going to be at the hearing level, which is the next step. So the initial level, you go in, you apply, you fill out a bunch of forms. You're going to fill out a disability report, your history, your work history. They're interested in what you've done over the last 15 years, okay? What kinds of skills you've acquired in your work activity. They look at your education. Education is very important. They look to see whether you have at least a high school education or more. If it's something less, it makes it a little bit easier to qualify. I always tell folks, better to talk sparingly than, than what I call diarrhea of the mouth. The best thing to do is just say what is and leave it at that, black and white, because they do use a lot of the descriptions to decide whether or not they're going to allow a claim or not. It gets a little bit crazy, at least at that first level. You will never meet that person or persons who are involved in the decision at that first level. When you were denied, you probably had a voice over the phone asking you, and you got a bunch of forms, activities of daily living, function report, right, basically, but you never saw any. Did they send you out for a consultative exam? Did they send you to a doctor? No. Okay. Generally, if you have a very supportive doctor, a doctor who really believes you are seriously disabled, the clue here is you don't know what that doctor has reported back to Social Security, but the clue is, okay, well, we're going to get a second opinion, and they'll send you out to one of their doctors for an evaluation. It's very common. They do this all the time. That's the clue, okay, that your doctor is supporting you. Sometimes you're going to be surprised as to what your doctor reports back to Social Security. He's not saying anything wrong, but he's not saying anything to help you either, basically. And you don't find out what he's saying until you're at the hearing level. Once it gets to the hearing level, then you get your complete record, everything that was accumulated in developing the medical issues of your case. Now, the hearing itself, which you're going to be going through, this is an informal, in a room similar to this, a little smaller. There's no audience. It's just you, the judge, your attorney, and then they usually have a person who's called a vocational expert. Now, what is a vocational expert? Vocational expert is somebody who knows all about jobs, okay? And that vocational expert is going to classify your past work in terms of skill level, exertional level, okay, and whether any of these skills can be transferred. That's,
In that letter,
yeah.
you know,
Now, may I ask how young you are?
over 50.
Okay. Here's why it's important, and this is your insight. They look at three things: age, education, and past work experience. The most important is age. Age. 50 is the magic age. The bar comes down. They call 50, now don't throw eggs at me now, I'm just the messenger, closely approaching advanced age. 55, the bar gets lower again. That's advanced age. 60 is closely approaching retirement age. And as you reach those age levels, the bar or the requirement of proof of disability lowers each segment. The thing that counters this is your skill level. In other words, let me give you a good example. Suppose we have a surgeon who develops severe arthritis in both of his hands. Okay, he can't go back to his previous job as a surgeon, but he's a doctor and he has skills. So he could have those skills transferred to another phase of medicine. That's what I mean. That's a graphic example of what I'm talking about. But certain skills will be significant in terms of transferability. But as you get older, that transferability gets lower. It has to be similar with the same tools, the same industry, the same work processes. They'd have to show that as you got age 55 and higher. So they make it a lot easier once you reach age 55. The other thing you got to remember is it's not so much what the diagnosis is, what the condition is, or combination of conditions. It's how those conditions affect your functioning. In other words, how long you can sit, how long you can stand, how long you can bend, how much you can lift, how much you can carry, reach, stoop, and of course getting along with supervisors, getting along with co-employees. Functioning is the key. That is what they're looking at, more so than the diagnosis. How does your condition affect your functioning? And the other key is, can you sustain work 5 days a week, 8 hours a day on an ongoing basis? 5 days a week, 8 hours a day on an ongoing basis. Those are the standards they apply in evaluating the medical in any claim. Okay? The hearing itself is informal, but your testimony is under oath. And you'll hear the judge pose what we call hypothetical questions to the vocational expert. You'll hear the judge say, well, assume a claimant of the applicant's age, education, and past work experience. Further assume that this person is suffering from, and they'll mention the diagnoses, that this disease or diseases or combination of diseases affects their ability to sit no more than 2 out of 8 hours, or lift weight no greater than 10 pounds, or walk no longer than 6 out of an 8-hour time span, with the usual breaks in the morning, in the afternoon, and a 1-hour lunch break. Assuming all those factors, could the person return to his previous work? And the answer is generally no. You can't go back to your previous work. But here's where it really hurts. Are there other jobs in the national economy this person could do? And that's how a lot of these cases are defeated. That's where advocacy comes in. That's where generally the key to success is at that point in the process. And they use a number of reference materials, the Dictionary of Occupational Titles, work patterns, I mean, a whole host of things. But I'm not going to go into long detail there. But that's how the whole process goes down. This is what happens during the course of a hearing. This whole process from the date you apply, denied on initial, request a hearing date, is about 11 months, total of about 11 months on average. Now, if you lose, that does not mean it's over. You can appeal. And the next step in the appeal process is a request for review by what they call the administrative, by the Council of Appeals Council. The Appeals Council is a reviewing body. There's no new hearing, but all they do is review the judge's decision to see if the evidence supports his conclusions. Now, if you lose at the Appeals Council, and that can take another 6 to 8 months to get that decision, that doesn't mean it's over. You can go into federal court. In fact, right now we have 27 cases in federal court, and you've got to be very selective because it is very long and involved. It requires what we call cross motions for summary judgment. In other words, there will be a scheduling order that says, and it'll be heard by a magistrate. The magistrate will hear the argument, review the briefs, and then make a recommended decision to the judge originally assigned to your case. That judge can either adopt the magistrate's report or reverse the magistrate's report. And it can go either way. It can approve it or reverse it. And I've seen it go both ways. And it can go even higher to the Court of Appeals. And even higher than that, even to the U.S. Supreme Court. Now, that's extremely rare, but there have been cases that have gone to the U.S. Supreme Court. Mostly dealing with child SSI. Particularly, there was a major case in 1990, and it was called Zebley, Z-E-B-L-E-Y. If you ever want to hear the history of the program, particularly the SSI program, you can go on the internet and just Google Zebley, Z-E-B-L-E-Y, and it'll be a very interesting. It was a 7-2 decision. Well, let me give you a little history because I think you'll find this interesting. SSI was created in 1974. It was a program that was started under the Nixon administration, passed by Congress, signed into law by Nixon. Co-sponsors, both Republicans and Democrats, started to take effect 1976. And what they were doing was, here we had all these federal dollars going to the states. We had 50 states, and these federal dollars were to go for disabled children, poor disabled children, and poor disabled adults. Well, you have 50 states. They had 50 different standards. Some were more liberal, some were more conservative, some treated children better than others, some treated adults better than other states. And folks would literally, when they'd find out, would move from one state to the next just to get an opportunity to qualify for disability, Medicaid, and other benefits, supplemental benefits. So what they decided to do, look, let's level the playing field. Let's have the same standard for everybody, for every poor disabled child and every poor disabled adult in the entire country. And so we'll pass the Supplemental Security Act, and since we already have in place a system, because the SSDI program, Title II, had been in place for years and years and years, since at least the early 50s, let's just put it under Social Security. And that's what they did. That's why even though it has nothing to do with SSDI, the program itself, Social Security was going to administer the programs. It was cost effective that way. So, okay, so SSI started, and I told you about the and they're pretty much the same requirements. Started back in still about the same. The children SSI program was awful. I mean, they were denying kids left and right, sick kids, poor sick kids, and it was challenged a number of times. And then finally in 1982, action was started in U.S. District Court saying that there was denial of equal protection of the law, denial of due process of the law, particularly equal protection for the children because they were held to a much tougher standard than the adults. Basically, that's what they were saying. So you lost in district court, you lost in the Court of Appeals, ends up U.S. Supreme Court, 1990, believe it or not. It's rare that you would ever see a case like this get to the Supreme Court. Sandra Day O'Connor, a conservative Republican, wrote the opinion for the majority of the court, including in the majority was Antonin Scalia, believe it or not, one of the most conservative justices, and they reversed Social Security by a 7-2 decision. And not only did they reverse Zebley, what they did, they told Social Security, you got to go back to 1982 and reopen every single SSI claim and re-adjudicate every single claim. And they did. More than 80,000 claims had to be reevaluated and gone through the process. And of those 80,000, I think it's about between 30 and 40,000 of those claims got approved. So it can happen. It can get to the Supreme Court. I mean, but from a practical sense, what I told you about the application, the hearing process, and the initial appeal process is about all that you're going to be exposed to. Yeah.
Cliff, since all of our clients here have cancer, and
Yeah.
cancer is a very dynamic disease and it can change.
Yes.
Can you talk a little bit, especially those that are represented,
Sure.
about why it's important to let their
Yeah.
lawyer know what's going on?
Yeah, very, very critical. Here's the way they make the medical decision. They ask 5 questions. It's 5 questions. First question, are you working? If you're working, making more than $1,040 a month, you're not considered, you can't qualify for disability, you're considered, you're working. So if you're not making that much, the next question is, are you suffering from a disease or condition that prevents you from working? Obviously, yeah, you do. The third question, does your condition meet a certain minimum requirement set by Social Security that automatically qualifies you for benefits? And cancer is covered under 3 sections. There's hematology and oncology, and there are specific areas of cancer that are covered that if you meet, those standards, you're automatically eligible for benefits. However, most cases, the standards are so high you can't quite meet them, and it has to be exact. It has to be right on the money. So the next step is the hearing before a judge. Now, how does your cancer affect your functioning? That's basically what it boils down to. And it is essential that you let your attorney know, if you're going through this process, any major change in your condition. This is very important because it's his or her responsibility to develop the record. That's what we call it, developing the record, obtaining the latest medical evidence that supports your case, and then before the hearing, preparing what we call a statement of law and fact. Basically, it's a brief setting forth your theory of the case as to why you should qualify for disability, using the 5 steps I just told you. Yes?
What if, prior to your cancer diagnosis, you also actually had depression, anxiety?
That dovetails right into it. That by itself could make you eligible. But by dovetailing both together, because most folks undergoing something so significant as cancer or any other major disease generally always develop some type of depression. We see this constantly. It's rare. I mean, you'd be a He-Man if you didn't, literally. So it's kind of expected. And so it's kind of expected by Social Security as well. But even by itself, that could be a basis for allowance of a claim. Coupled with the cancer makes that case far more formidable and should be allowed. But understand, these judges, they run the gamut. There's conservatives, there's liberals. You got to get lucky on who your judge is, basically. Yeah?
So one other thing too, along with Cliff is saying, is that as you're waiting for your hearing, if your cancer recurs or progresses, you want to let your attorney know.
Absolutely.
Sometimes we cannot have to wait till the hearing.
Right.
We can get an on-the-record.
Yeah, I'm glad you brought. Good, great, thanks, Kathy. That really is important. A skilled attorney who does this quite often, particularly since you're waiting 11 months to 14 months for a hearing. God forbid your condition gets much worse or takes a turn for the worse. The attorney can be aggressive and say, well, gather these records showing this event and then contacting the hearing office where your case is pending and try to get hold of one of the attorney advisors to request what we call an on-record decision. Now, there's 2 ways to do this, 3 ways actually. We prepare a written statement as to why we believe, with the current development of the latest tests and lab results, this case now takes on a new posture and should be allowed based on the medical evidence alone without the need of any testimony. What that does is it shortens the period that you have to wait to get your claim approved. Now, OTRs, that's what it's called, OTR, on the record, OTR, that's what it's called. If you haven't asked your attorney about that, you should. Do you think I'm a candidate for an on-the-record decision? And let them know that you attended a seminar and this was brought up as a way to expedite the final adjudication of your case. This is important. Sometimes, particularly when it's just egregious what the first level of decision makers come up with and the case gets to the hearing, I alert the staff attorney before the file even gets there. This is a case. Flag this case because it is a case that should be considered for an OTR, on the record decision. And if it's there and there's strong evidence of support from your treating doctors, yes, you are going to see an OTR. Now, sometimes they'll say, well, okay, I don't think you quite had enough as of this date, but if you agree to an onset date of this, we'll go ahead and give you that on-record decision. And that saves you literally months and months and months and months of waiting. So definitely, if you have a claim pending now, definitely explore the possibility with your attorney. It's not unusual, and it's done quite often. Believe me, it is. Any other questions I can answer for you?
I'm just gonna interrupt 1 second. I'm gonna be setting up lunch here. Cliff is gonna still be here till noon. but
Yes.
I want to let you
Yeah.
know there's also gonna be food here too, and he loves direct questions because he has a wealth of knowledge, so go for it.
Yeah, and if you don't feel comfortable asking among, some folks aren't, I understand that, sense of privacy. Call me directly. You can get me at that number on the, and ask for me specifically. Now, there are 2 Cliffs in my office. My partner's first name is Cliff, but you ask for the good-looking Cliff.
He always says.
Yeah. No, I got him trained because he's 10 years younger than me, and he always says ask for the younger Cliff, so I get even with him. We've been going through this since 1979. That's how long we've been partners.
Okay, after I was denied, they told me I was going through appeal, they gave me this little diary I have to.
It's not a bad idea just to keep track of anything because we forget sometimes. And it's a good idea. That's a great idea. What we do, we send out every 6 weeks what we call medical updates.
Right.
And we mail them out to you with a self-addressed envelope. What's changed? Everything the same? Put down. Everything's the same. No new development. But we also tell our folks, don't wait until you get that medical update form. You pick up that phone and call us because you may be a candidate for an OTR with that development, you see? So it's a two-way process. You've got to help your attorney help you, and this is the best way to do it, believe me. Keep them aware of what's going on in your treatment plan and any new developments, any side effects from medications, any new treatment that they're going to be doing. Let him know. Let him know. Any other questions I can answer for you folks? Yeah.
No, I was denied. I didn't know about appealing or anything, so I didn't. I just assumed.
How long ago was that?
That would have been probably the end of 2012.
Okay.
So, what I'm trying to find out is,
Well, let me get a little history from you. Do you have a work history?
yes.
Okay. And when did you stop all work activity?
Well, I retired in 08.
Okay, when did you retire?
I retired from DTE Energy.
Okay, when?
2008.
Oh, you have a 5-year window to qualify for disability. So you have through at the end of 2008? No? It'll be 2013. You can file again.
But I used to have a 5-year window.
No. That means, here, you filed a year ago?
Yes.
Okay. Alleging an onset date, but you never took it to hearing.
No.
File a new claim.
Okay, so I filed a new claim.
File a brand new claim alleging, another date. You can allege any date because you haven't had a hearing. There hasn't been a hearing before a judge adjudicating your claim. You can file a new claim.
Okay, now if I come to you all or I call you or
Yeah.
whatever, do I bring everything that I have?
We'll ask everything, including your jockey short size. Let me tell you.
Everything I filled out, I kept.
That's fabulous. 99% of the people don't.
Oh, okay.
That's very helpful.
Okay.
Now, because you look pretty good to me, great.
Thank you.
We'll file it. We'll file the application. I got you beat by 11 years. Got you beat by 11 years. You don't even get near a Social Security office.
Okay.
I bet you were looking that good when you applied.
I applied online when you said online.
Whoa! Oh!
I had
right in the
somebody
gut.
help me, but I still did it online.
That's
It was
okay.
so much,
Hey, that's.
But I didn't have them sign their name or
Do you mind telling me your diagnosis?
non-Hodgkin's lymphoma.
Yeah. Okay.
But I've been in remission now for
Fabulous.
16 months, but I
Fabulous.
have a lot of after effects.
I can imagine. I can well imagine. Believe me, it's not so much the disease,
Right.
and it gets it's all the things it leaves you with.
That's what I thought.
The side effects of the treatment can be disabling by themselves. Tell me about it. Okay, where do you live? What community?
Southfield.
Okay, that'll go to Oak Park,
Okay.
which is good. Yeah, give me a call.
Okay, in fact, I'm not too far from, I'm in a 28,000 block, and I see your office is 25,000. I'm right behind that Myers.
Oh, I know where you're
12
at.
miles
Sure,
Right
sure.
behind that Myers up there.
Well,
12 miles.
we'll be more than happy to help you out. Give me a call, and we'll make an appointment and have you come in, and we'll take care of business. Here's the way we get paid. We get paid only if we're successful and you're approved. Social Security handles it. It's 25% of the accrued, that is going back from the date benefits should have started to the date they actually do start, actually the favorable decision. They'll withhold 25% up to a maximum of $6,000, whichever is less, and that's the attorney fee. If we lose, you don't owe us a dime. But yeah, that's, may I ask another tender question? You said you're 60?
Yes.
Oh, I've died and gone to heaven with your case. Oh yeah, I think I can help you.
Thank you.
I think I can help you.
I'm glad to be here. I'm blessed to be here at 60.
I hear you,
I had
girl.
a rough 58,
I hear-
59, but 60.
I hear you. I hear you. I hear that story every day. You bet.
Okay.
Yeah. Yes, ma'am.
Okay, I'm 61.
Oh.
Oh.
I went through my process.
Yes.
I went through my process and, you know, they got it, I guess.
You were
I had my
approved?
surgery.
Okay.
I had my surgery and everything. But now I'm dealing with the side effects too.
Yeah.
All the side effects.
Yes.
Now, will my disability continue just because
You have nothing to worry
I
about.
got it?
You have not. Was it based on your earnings? You got benefits, or was this an SSI case? Your earnings, SSDI, right?
Yes.
Yes. No problem. You will not have a problem. They do tell you they review. Now, that's true. For the younger folks, they do have what they call, they categorize your case at the time you're approved. And the three categories are expected to improve, may improve, not expected to improve. Not expected to improve, it's a 7-year review date. May approve is a 5-year review date. Expected to improve is a 3-year review date. Once you reach somewhere between 55 and 60, they're not going to review you anymore. You're so close to retirement, it doesn't pay for them to do it. I mean, they could, technically they could, but they generally don't. But if you're under 55 and you've been on the program and have been receiving benefits, let me tell you right now, it is essential that you continue to treat with your doctors because you will be reviewed. Believe me, what's going on in Washington right now, Social Security and SSI are in their gun sights. I mean, they just had a hearing yesterday about a big fraud deal down in Puerto Rico, and it's attack time. I'm telling you, I've been through this. This is the 4th series of attacks on the whole program. They do it out of lack of knowledge, but they do it because it's political, and that's what's going on right now. So whatever you do, don't stop treating. Don't think because a lot of folks, once they're on, they think they're on forever. You're not. You can be reviewed, definitely. You can be reviewed and will be reviewed. Because one of the things they are going to do, from what I understand, is appropriate monies strictly to do these, what we call continuing disability reviews, CDRs. I told you, they love acronyms. Yeah?
What if you retired and then you became a cancer patient or ill?
No. Yeah, if you're full retirement age, and are you over 66?
I'm 74.
No. There will, disability ends when you reach full retirement age, and they just convert it to retirement. No change in benefit, same amount, but they call it now retirement, and disability no longer applies.
Now, once you hit that retirement stage,
Mhm.
you have to change it from.
No, they'll do it automatically.
They'll do it automatically.
Yeah. And you don't want to do anything until you reach full retirement age anyway. In your case, it'd be 66. Yeah.
I have a question. A lot of people will ask me this. So if I get disabled at 60, does it flip to retirement at 62?
No. When you reach full retirement age. If you're born before 1951, it's 66. After 51, it's 67.
So it's just called disability
It's just called, same amount. In other words, disability is the same as if you reach full retirement age, okay? And doesn't change anything. The one thing it does do, once you reach full retirement age, let's say you got an opportunity to go back to work in some capacity. You can go back to work all you want. It doesn't affect your Social Security. So that's the one advantage. But you can work something out. Oh, that's the other thing I should point out to you. If you are on Social Security disability and been on whatever, and you want to try to go back to work, there are programs that we can outline for you that will allow you to test your ability to return to work and not lose any of your benefits. It's called the trial work period. And with SSI, though, it's a little bit different. But if you have that situation, give me a call and we'll figure out what you can do and what you can't do, okay? Any other questions I can answer for you folks? No?